It depends, of course, on exactly what you're applying for, but usually they will ask you to send in the names of any doctors that have treated you for the particular condition. They will ask you to send medical records if you have them showing treatment for the particular condition you're talking about. They'll ask you for evidence explaining how your condition is related to your military service. In some cases, your service medical records will have all the information. It will show that you got hurt on such and such a date, such and such a location, and that will be sufficient to show that your current problem is related to your time in service. In other cases, and unfortunately quite commonly, there won't be any record in your service medical records that shows that your current problem is related to something that happened in the service, or your records may not even show something that happened in the service. So there will be times when the information that they're asking for is not only the medical information, but also information showing what happened to you and showing that it did happen while you were in the service. Just as an example, I was recently working on a case where a person was hurt in an auto accident while they were in the service. They were not on the base at the time it happened, and the injuries were fairly serious, so that they weren't treated on the base. They were taken to the nearest hospital, which was not a military facility. So these records actually did not show up in the service medical records, and we had to get them and submit them to explain that this person really was injured while they were on active duty. One of the things that is interesting about veterans benefits is that as long as you sustained the injury during a period of active duty, even if you were not on active duty in the sense that you were on a military facility or performing military duties at the time you got hurt, you're still potentially eligible for service-connected compensation. Even in situations where, for example, you were injured while you were on leave or otherwise away from the base. So there will be times when the VA is not only looking for information about the medical side, but simply information to prove that you actually were injured and that it was during a period while you were on active duty. Sometimes the Veterans Administration will ask you for what they call buddy statements, which are simply statements from people who were present at the time you got hurt or know about an illness or injury that you suffered, so that you can use that information to prove that this happened while you were in the service or that it was related to service. Those can be very valuable pieces of information. So the VA will try to gather that information, put together the information that they can about what happened to you, about the medical results, about how you think it's related to service. And then once they've done that, they will issue what they call a rating decision. And they used to be somewhat longer and more involved. They've gone to a shorter format now, but essentially the rating decision will say, you applied for benefits, you've told us that this is the benefit that you want, and this is the condition that you think is related to service, or that you think justifies pension benefits. And then they will tell you whether they're granting that benefit, whether they're denying the benefit. Sometimes they will send you a letter saying that before they can make a decision on the benefit, they want you to go to a medical examination that they scheduled, or sometimes they will ask you to provide other information that's necessary for them to figure out whether they believe that your condition is currently disabling and related to your medical service. One thing that sometimes comes up is that people will wait too long. They'll have a problem. They'll go through medical treatment. They'll get to the point that they've recovered, and then they'll apply for benefits. Unfortunately, that won't work. You have to have a current disability at the time you apply for benefits in order to be eligible for benefits. If you wait until you've recovered, the most that will happen is you may be service connected at 0% for that condition. What that will do is think of it like insurance. That will protect you if that condition recurs or gets worse again, so that the next time it comes around, you'll already be service connected. You'll be potentially eligible for benefits, cash benefits at that point. But if at all possible, if you have a condition that you think is service connected and it's causing medical problems, you should apply right away, because unlike Social Security disability, for example, there aren't any retroactive benefits in the VA system. You can only get benefits from the date that you apply. So if you have a medical problem and you don't apply, you can't get benefits later on. So it's really important to apply as soon as you understand that there's A, a medical problem, and B, it may be related to service. You don't have to wait until you can absolutely prove that it was related to service. One of the important things about the VA system is, unlike a typical court case, you don't have to bear the burden of proving that your condition was related to service. The VA will actually make an effort to try to develop that information and come to their own conclusion about whether it was related to service, which is one of the reasons that sometimes they'll send you out for a medical examination. As I mentioned, that's one of the ways that they help their adjudicative staff to figure out whether or not they can demonstrate that your condition was related to service. But you're not limited to the opinions of the VA doctors. If you go to a VA exam and their doctor says, well, I can't figure it out, or I don't think this is related to service, you can submit your own medical evidence from your own doctor showing that your doctor thinks it's related to service and explaining why, and sometimes that will be sufficient to persuade the VA. Sometimes it won't, but obviously it's to your benefit to submit all of the information that you can, medical and otherwise, that demonstrates the connection between whatever condition you have and your service. Now, some kinds of conditions are pretty easy to demonstrate, and the VA is pretty good about recognizing them and paying them. We've all seen on the news of the people who have been injured in the recent conflicts in Afghanistan and in Iraq. There have been a lot of what they call improvised explosive devices, IEDs, basically roadside bombs. And people have had some fairly devastating injuries from those. And those kinds of cases, the VA is usually pretty good at handling. I mean, if you come in and you've lost part of a leg, they're not going to quibble about it being service connected. They can see what's going on. They can rate the injury. Those go pretty smoothly. Harder ones are things like people who come back from those conflicts and they develop post-traumatic stress disorder, or they develop serious depression. It becomes much more complicated sometimes to prove that those things came from the military service rather than from some other source. Unfortunately, people with PTSD, one of the hallmarks of that disorder is difficulty getting along with others. So you see people come back, They start to have marital problems. They have all kinds of difficulty at work. They go to the VA and they apply for benefits and they say, gee, I've got PTSD, I should get benefits. And the VA says, well, no, we think that really your problems are all related to your current domestic problems. You know, you're in a bad divorce or having a tough time with your spouse, and really that's what's going on emotionally, it's not PTSD. So you get those kinds of issues, but the process continues the same way. Once the VA makes a rating decision, if you like the decision, you're happy with it, you can stop there. If you think that even though they've looked at everything that you submitted, they got it wrong, you're entitled to appeal. And the way you do that is to submit a written statement saying you think they got it wrong. They call that a notice of disagreement. It doesn't have to be anything fancy. It does have to be in writing, and the VA has to get it within 1 year of the date of the rating decision. Those are the only two critical points. It also has to say that you want to appeal. It's not enough to say that you disagree. You have to specifically say that you want to appeal. But as long as you get something in writing, saying that you disagree, saying that you want to appeal, you do that within a year, that's all that's required to start an appeal. Once you do that, the Veterans Administration will then give you the option of what they originally called a decision review officer review, or now they call it de novo review, but they give you the choice. You can have this additional special look at your case or not. It's up to you. The clients that I work with, I always recommend that people do that. It's relatively quick. We've had pretty good results in the sense that a lot of people who got turned down originally got benefits at that level. So I encourage people to do it, but you're not required to. It's optional. The other point I want to make about the process is if the rating decision is favorable in the sense that they say, okay, we agree that your leg injury should be service-connected or your depression should be service-connected, and we're going to rate you at 20%, say. You can appeal that if you're not happy with the rating decision level of rating. If they give you, say, 10% or 20%, and you think it's a more serious problem and it should be rated higher, even though they granted benefits, you can still appeal. You're not limited to what they give you for rating. So typical appeals involve either a denial or a rating that someone thinks is too low. And you can appeal either of those. It's the same process. You file a notice of disagreement, and you can opt for the DRO or de novo review. Regardless of whether you opt for that, the Veterans Administration, the Department of Veterans Affairs now, will issue what they call a statement of the case. And the statement of the case is just a written statement from them. Usually it runs 10, 12 pages, sometimes more. Sometimes they throw in lots of boilerplate about the law. But the essence of it is they will say, we got this claim. These are the things we considered about the claim. This is what we decided. This is why we decided. And it's supposed to tell you what went wrong, if you will, in terms of getting your claim granted. It's supposed to point out what the problems are or the reasons why they don't think they can grant you benefits. Once you get that statement from the VA, to complete your appeal, even though you've already filed your notice of disagreement, you have to file what they call a Form 9. It's just a one-page form. You can get it on the internet or from the Veterans